So Indian Gaming Regulatory Act is what we're on. The court case that got the Indian Gaming Regulatory Act in motion, California versus Cabazon Band of Mission Indians. What does PL 280? How does PL 280 affect the gaming industry?
California was a mandatory 280 state, so they had criminal jurisdiction, and yeah, I know
not civil, but just criminal.
Yeah,
Right.
and it's like regulating games would be civil, but they were trying to call it like criminal.
Yeah, California made the argument. Excellent, Mike. You got it. California made the argument that they were prohibiting games by Cabazon and Morongo. The Cabazon Band of Mission Indians and the Morongo Band of Mission Indians were in on this. So California said, no, they're just breaking the law. We have, it's a criminal prohibitory suit. So they're obviously breaking the law. And what the court found that no, California already permits all kinds of gambling. What they're trying to do is regulate the Cabazon Band. And in fact, what they're really doing is they're trying to shut down the Cabazon Band because they don't want competition. California already has all kinds of gambling. So that really, I mean, if you've had the opportunity to listen to any of these oral arguments through the OYA site, if you've had the opportunity, have any of you listened to this one? It's really not that long. It's about an hour long. It's well worth your time, because the California, the attorney arguing for the state of California just goes trips all over the place, and it's not pretty. But anyway, it's interesting to listen to. So being a PL 280 state and finding that in this case, bingo was not subject to criminal prohibitory criminal prohibition, but was merely regulatory. They gave the green light to tribes in all the other states where there was some form of gaming. Oklahoma being a state where there was not anywhere close to casino gambling, but certainly there was pari-mutuel betting, and that was one way that the state, that kind of stopped the state from having a truly criminal prohibitory argument against bingo halls. And of course, in the case of Oklahoma, there was 1987 was, we were already a decade into gaming easily in the state. Their tribes had all kinds of games prior to that. And they had done that, of course, at the behest of the federal government. The federal government during the 70s and the 80s encouraged tribes to do whatever they could to make money. And if that required sort of utilizing their sovereignty to perhaps circumvent state taxes, then they had the green light to do that. So they did it. And the states often didn't like that. State tax commission would come down hard on the tribe sometimes, and that sometimes led to problems. Well, in 1988, following this Supreme Court case, Congress hammered out a pretty convoluted, complex law called the Indian Gaming Regulatory Act. And under the Indian Gaming Regulatory Act, we talked about this, there were There were created a lot of new things. Number one, um, it, it allows, in some ways, it might be said that the Indian Gaming Regulatory Act is a lot like PL 280. It places state regulatory power over the activities of Indian tribes. And the way that it does that is it forces tribes and states to come together and negotiate compacts. And those compacts then sort of create the rules of Indian gaming. The objective, of course, was that certain states that were adamantly against having any sort of Indian gaming would basically be able to limit what tribes could do within their borders. Of course, a lot of the tribes thought this was unfair. We have every right to do this within our territory. So 1988 to 1996 were kind of the years that the Indian Gaming Regulatory Act was actually in effect as written. And the way that worked was that you had the law created 3 classes of gaming. I think I've already discussed this, but we'll review it. And sorry for these awful notes. So here are the classes. We've got class 1 gaming, social games, minimal prizes, basically the total jurisdiction of the tribes. These are like powwow raffles and stuff. Class 2 games were what Oklahoma tribes had at the time. They were bingo type games, high stakes bingo. This is what Cabazon was all about. So there was kind of a gray area between class 2 gaming and class 3 gaming. But with class 2 gaming, the law required the tribes to have their own gaming commission. So every tribe had its own gaming commission, and a law, the tribe passed an ordinance to regulate gaming. Class 3 games were what everybody wanted. And class 3 games were casino style, Las Vegas, Atlantic City style gambling that could actually make a lot of money, because the big difference between class 3 gaming and class 2 gaming is what? Do you recall? Class 3 games include games where you're playing against the house. And if you're playing against the house, nobody ever wins against the house, right? The house is always going to be making the money. So it's not required, the number of people showing up doesn't really matter. Well, it does matter. But, so anyway, in class 3 gaming, those have to be conducted in accordance with the tribal state compact. So compacting is really just for class 2 or class 3 games. And that's where the states, basically the governor of the state, negotiates with the tribe to come out to negotiate a compact. And that compact has to be approved by the Department of the Interior, also has to be approved by the National Indian Gaming Commission, and has to follow the provisions of the Indian Gaming Regulatory Act. So there's quite a bit of there was quite a bit of leeway in working together. Now, the one interesting side of this, before 1996, if a governor decided that he just wasn't going to negotiate with a tribe for a compact for class 3 gaming, then the tribe could actually sue the governor. Okay. This was the leverage that the Igra gave the tribes with regard to the gaming. So that was really important, but it was overturned in 1996 with Seminole Tribe versus Florida. Seminole Tribe of Florida versus Florida. Okay. And in that instance, let me see if I can find. I bet we have it. Let's see here. Seminole Tribe. Seminole Tribe of Florida versus Florida. There it is. Yes. Okay, here it is. You ready? Actually, there's two of them. Let's see, how should I do this? Tell me if this works. Can y'all see that? Sorry.
It's zoomed in really far, but yes.
Can you see it? Okay, here we go. Oh. This is kind of a long one. It's by Quimby though, so here we go.
In 1988, Congress passed the Indian Gaming Regulatory Act to promote and regulate the Indian tribal gambling industry. If an Indian tribe wanted to set up gambling on tribal land, the tribe needed to negotiate an agreement with the state. The act required states to negotiate with the Indian tribes in good faith. If a state refused to negotiate fairly, then the tribe could sue in federal court to compel negotiation. The act specifically gave federal courts jurisdiction over these cases. Florida's Seminole tribe wanted to set up gambling operations, but Florida refused to negotiate. The tribe sued the state and its governor in federal court to force them to the negotiating table. Florida claimed that the act violated its 11th Amendment rights by authorizing the tribe to sue the state in federal court. The district court denied Florida's motion to dismiss, but the Court of Appeals reversed. The Supreme Court granted cert to decide whether the 11th Amendment protected the state of Florida from the Seminole tribe's lawsuit. The court held that deciding whether Congress can take away the state's 11th Amendment protection requires a two-step analysis. First, Congress must express an unequivocal intention to take away the state's 11th Amendment immunity. Second, Congress must have removed the immunity under a valid constitutional power. Chief Justice Rehnquist, writing for the 5-justice majority, held that 11th Amendment immunity protected Florida from this lawsuit. Although Congress satisfied the first step by expressing a clear intention to remove the state's immunity, Congress had not acted under a valid constitutional power in doing so. Congress passed the Indian Gaming Regulatory Act pursuant to the Indian Commerce Clause, which granted Congress exclusive authority over commerce with Indian tribes. But under the American federal system, states are still considered sovereign entities. As part of that sovereignty, states generally can't be sued without their consent. This doctrine is called sovereign immunity. The 11th Amendment protects state sovereign immunity by prohibiting federal courts from hearing cases brought against the states by private parties. But sometimes Congress can take away the state's sovereign immunity. For instance, Section 5 of the 14th Amendment authorizes Congress to protect civil rights from state infringement. That authority includes the power to authorize private individuals to sue states in federal court in actions to enforce these civil rights. Similarly, in Pennsylvania versus Union Gas, a splintered plurality ruled that the Interstate Commerce Clause also granted Congress the power to take away state sovereign immunity. Following Union Gas, the Seminole tribe argued that the same rule should be extended to this case, since there was no convincing reason to treat the Interstate Commerce Clause and the Indian Commerce Clause differently. But after reconsidering the issue, the court overturned Union Gas. The court held that the Interstate Commerce Clause and the Indian Commerce Clause were both fundamentally different from the 14th Amendment. The 14th Amendment was specifically enacted to alter the balance of federal and state power. The Interstate Commerce Clause and the Indian Commerce Clause both gave Congress legislative power over their respective subjects, but they didn't alter the fundamental limits of the federal judicial power under the 11th Amendment. Therefore, neither the Interstate Commerce Clause nor the Indian Commerce Clause allowed Congress to take away state sovereign immunity, and Congress couldn't rely on those parts of the Constitution to authorize the tribe's lawsuit against Florida. The majority affirmed the judgment of the Court of Appeals, agreeing that the tribe's suit was barred by Florida's right to sovereign immunity under the 11th Amendment. Justice Souter, joined by Justices Ginsburg and Breyer, dissented. Souter argued that the majority based its decision on an overly broad interpretation of the 11th Amendment. Souter argued that the 11th Amendment, by its plain language and history, barred only diversity cases brought against the state by a non-resident. In Souter's view, the 11th Amendment didn't bar federal question cases brought by individuals against states, which was the type of lawsuit here. Justice Stevens dissented separately, emphasizing that by overruling Union Gas, the court potentially undermined a number of federal legal claims. This included claims arising from intellectual property, environmental law, and economic regulation. Seminole Tribe of Florida versus Florida limited Congress's power to create private causes of action against state governments that violate federal law. However, subsequent decisions have diminished Seminole Tribe's impact by allowing Congress to take away state sovereign immunity in matters concerning bankruptcy and discrimination.
Wow, that is a deep explanation that is far above my head. So all you really need to know for this class is that Florida won, and it was, that's a pretty gray area, isn't it, for the Supreme Court? They were all split. It was all kind of a very subjective call, and so basically, this placed a limitation on what tribes could really do. They couldn't leverage their governors anymore. So pretty much the tribes that had worked out agreements with states continued, and the Seminole, like in the case of the state of Florida, wouldn't have it. A little bit more on Indian gaming in general. It's clearly the largest single revenue producer for tribes across the United States. It has, however, gaming is not taken up by every Indian tribe, though. There are a lot of tribes that don't have anything to do with it. And of course, there's the geographic limitation of casino gambling as a revenue producer. Okay, here are my notes. Florida objected to the Indian Gaming Regulatory Act's requirement to have states negotiate with Indian tribes to determine state tribal compact provisions. What gives federal government authority to force states to negotiate? So that was the issue. The 11th Amendment issue, which constitutional authority is bigger, the Interstate Commerce Clause or the Indian Commerce Clause? And so 5-4 decision on Seminole Nation, clearly very gray. The Indian tribes and Congress basically were battling it out with the states using the 11th Amendment in the Constitution. So kind of interesting there. The states that don't want tribes to have casinos have a good deal of authority now to hinder them from getting the most out of the Indian Gaming Regulatory Act. That's about it. Bay Mills Indian Community. The Michigan versus Bay Mills Indian Community is also provided in this chapter again, but we've already read about that, and you know what happened there, right? The tribe authorized games beyond the reservation off Indian land. So, of course, Michigan sued the tribe, but the Indian Gaming Regulatory Act does not have a provision allowing states to sue for off-reservation Indian gaming. So the tribe pulled a fast one on the state of Michigan